Thank you. I'm Professor Jonathan McLeod, Professor of History here at Diego Mesa College. We want to begin with a few acknowledgments. We want to acknowledge President Pamela Lester, President of Mesa College, and we want to acknowledge Victoria Miller, who's the Dean of Student Affairs here at Mesa College, for their support. Also Charles Zappia, who's the Dean of the Social and Behavioral Sciences Department, Multicultural Studies, and Architecture, for their support. We have several sponsors for this event: the Department of Social Sciences, the Student Affairs Office, the Humanities Institute, and the Financial Aid Office. I also want to acknowledge Carlos Wales for all his support in setting up the technical parts, and Carlos Pelayo, who is due for an Academy Award or an Emmy or something like that in the near future. Okay. This morning I want to introduce our Vice President of Instruction, Dr. Isabel O'Connor, who will welcome you to San Diego Mesa College, and then I'll return with a few historical moments and we'll get right into the proceedings.
Good morning, everyone. What a great pleasure to see such a large group of students here gathered to celebrate Constitution Day. But my first question, of course, is what is Constitution Day? Help me out. What do we celebrate today? Come on. Extra points. A hand somewhere? Yes, I saw a hand. What? Okay. All right, I will help you out. So on this date, September 17, 1787, the Constitution of the United States was signed. That is a very important day, but in my book, it's not just Constitution Day is today, right? Constitution Day should be for all of us every single day, because that document is of the highest importance for us. The Constitution sets up the basis for our government, the checks and balances, the rights of the citizens, and so forth. But let me tell you, it's more than that. I'm a medievalist, right? My century is the 13th century, the 1200s. The closest it gets to the Constitution is the Magna Carta in England. I'm from Spain, we didn't even have that. And on top of that, I grew up under a dictatorship. So when I came to this country 33 years ago, and eventually became a United States citizen 10 years ago, all these things really meant something to me. I will never forget the first day I voted on US soil. I was living in Indiana. Okay, and I was scheduled to have a root canal. And I was just really excited to exercise my rights as a citizen in a country in which I had lived for a long time, and now I felt I was part of. So I told my dentist, hurry up, I have to go vote. I don't care how much it pains me. My smile was from ear to ear because it was the first time in my life that I exercised the right to vote. I couldn't do that in my own country, Spain. Okay, sob story is over, right? My message to you is that the Constitution is not just a booklet, it's not something you put on your bookshelf. It's something that we live. It's not a passive document. It's a document that guides us towards who we are as citizens and how we change society, right? And I can't think of a better place to start having that conversation of what does it mean to be a citizen of the United States or the world. What do you do in the face of injustice and bigotry and all the things that affect our society, particularly now? You come to action, and it is this document that guides your actions. So in a college campus, and I'm a historian, just like Professor McLeod, and other people here. In a college campus, whether it's in the humanities or the social sciences or other disciplines, our goal is not just to convey to you a lot of information. It's not for you to memorize these facts or even what the Constitution says. It's for you to analyze and bring to your life parts of that document that guide your actions as a citizen. So yes, it's critical thinking and analytical skills that when you walk out of here of Mesa, you're well prepared to change society. And when faced with bigotry and injustice and all these things, you are ready and you feel that civic responsibility to act. That is really important. And you already took a lot of first steps because you are here to celebrate Constitution Day, which is every day. And we're all going to be treated to a fabulous moot court. So I am ready to learn, and I am in awe to see what we have in store. Thank you for allowing me to say at least a few words. Thanks.
Okay. So being a U.S. historian, I'm going to speak a little bit more about history to set up a little bit of context. So to further a bit of on what Dr. O'Connor was saying, on the 17th of September, 1787, that's 232 years ago, the people of the new republic, the United States of America, were caught up in a battle over the framing and ratification of the proposed Constitution of the United States of America, which was drafted by delegates to the Constitutional Convention that had convened in Philadelphia during the late spring and summer of 1787. This document was designed to replace the original framework for the government of the nation, which was called the Articles of Confederation, which had been in place from 1775 and would remain the foundation of government until 1789. There was, at this time, a broadly recognized need for a new constitution that would strengthen the national government. Subsequently, after months of intense political struggle, on the 2nd of July, 1788, the new constitution was declared ratified. At that point, 9 of the 13 states had consented. Eventually, on the 29th of May in 1790, Rhode Island, the last holdout, joined with the other 12 states in ratifying the Constitution. Along the way, the approval process necessitated compromises, which led the members of the new United States Congress framing amendments stipulating the rights of Americans. Ultimately, by December of 1791, 10 of the numerous proposed amendments had been ratified. These 10 amendments became known as the Bill of Rights. Since 1791, an additional 17 amendments have been ratified. Of these latter amendments, the 14th Amendment to the Constitution, ratified in July of 1868, at the conclusion of the United States Civil War, defined citizenship for the first time, together with the privileges and immunities of state and national citizenship. The amendment also affirmed that all persons within the jurisdiction of the state are guaranteed equal protection under the law. However, on the issue of voting rights for the former slaves, remember this is right after the Civil War, on the issue of voting rights for the former slaves, the amendment only penalized states which still denied the vote to adult males, including the former male slaves. The first insertion of gendered language into the Constitution here in the 14th Amendment was a crushing blow to the women's suffragists, the women who were advocates of women's right to vote. Subsequent narrow judicial interpretation of the Equal Rights Protection Clause of the 14th Amendment by the federal and the state courts, and enactment of legislation which circumvented those equal protection provisions of the amendment with respect to race, resulted in decades of justice being denied to broad segments of the American citizenry who were identified as non-white and or as female. Organizing by supporters of women's rights at the state level, especially in the 1880s and afterwards, and finally at the national level, culminated in the ratification of the 19th Amendment in 1920. This began to chip away at the distinctions on the basis of gender included in the 14th Amendment by establishing that the right to vote henceforth could not be denied on account of sex. Now note here the thinly disguised distinctions on basis of race still persisted, with Jim Crow laws and the conventions of segregation defining social relations across the nation. Culminating decades more of civil rights and women's rights advocacy, in 1964, Congress passed and President Lyndon Baines Johnson signed into law the Civil Rights Act of 1964, which outlawed discrimination on the basis of race, color, religion, national origin, and sex. As you will see, the word sex is the subject of much controversy on matters of sexual and gender identity. With respect to employment rights, does the Civil Rights Act prohibition of discrimination on the basis of sex apply to the actions of employers against employees who identify as homosexual, bisexual, transsexual, or queer? Today's Moot court hearing will present some of the key arguments that will presumably be raised in early October, I think it's October 7th, in front of the U.S. Supreme Court. In the process, highlighting the relevance of the Constitution to our daily lives, and it will show why politics and law in our world today are best understood in a historical context. So thank you for joining us in observing Constitution Day 2019. It's my privilege now to introduce Professor Stephen Semeraro of the Thomas Jefferson School of Law, who will make more introductions, and finally we're going to get to the meat of the presentation.
Thank you, Jonathan. I'm very pleased to be back for the fourth time, the fifth time, to celebrate Constitution Day with you at Mesa College with the Thomas Jefferson School of Law Moot Court team. The students put a lot of hours into preparing these arguments for you, and I think that they're going to do a wonderful job. I have the pleasure today to introduce my colleague on the Thomas Jefferson School of Law faculty, Professor Julie Greenberg. She is a leading expert in the area of gender identity, and her writings have been cited in state and federal courts in the United States, as well as by courts in other countries around the world. Her book, Intersexuality in the Law, Why Sex Matters, won the 2013 Below Book Award for the most distinguished book written for the professional sexological community. She's also been voted a top attorney in academics in San Diego 7 different times. So we're very lucky today to have Professor Julie Greenberg.
Good morning, everyone. So today I get to talk about my favorite topic, sex. And what we're going to be focusing on in today's arguments is, what does the term sex mean? More specifically, we're going to be focusing on the argument of, or the issue of, what does sex mean when we're talking about ending discrimination based on sex? So when you think about the statutes that are out there, there's 2 types of statutes that we have both at the state level and at the federal level. Some state statutes, as in the first category, specifically ban discrimination based on sexual orientation and gender identity. Most federal statutes and some state statutes, however, don't get into the specific language of sexual orientation and gender identity. They only ban discrimination based on sex. And so the question then becomes, does the term sex also ban discrimination based on sexual orientation and based on gender identity? These cases have been percolating all over the country. We're getting really contradictory opinions, which is when the Supreme Court usually decides to grant cert and hear a case. So this term, the Supreme Court has granted cert and is going to be hearing 3 cases on this issue. 2 of the cases involve discrimination based on sexual orientation, which we're not going to be discussing today. The case we're going to be discussing today, Harris Funeral Homes, it involves somebody who was fired when they came out and said, I am transgender and I'm now going to start coming to work as a female. So that's the case that we're hearing arguments about today. What's important to keep in mind is that this case, obviously it's really important because it applies to all workers, so it's got very broad implications. But what's very important to keep in mind is the arguments and how this case is resolved is going to have really wide implications just beyond the employment setting, because there's so many other provisions, statutes, regulations, the Constitution, that also bar sex discrimination. So how the Supreme Court decides these three cases will have broad-reaching implications. What I put on the slide is the four biggest areas, but there's plenty of other statutes as well. So the 14th Amendment prohibits discrimination based on sex, the Equal Credit Opportunity Act, so lending provisions, housing acts, and importantly, Title IX education also prohibits discrimination based on sex. So how the court decides Title VII's definition of sex will also affect these other areas. It's important to keep in mind the history here as you're hearing these arguments. Often when courts have to interpret statutory intent, they have a legislative history to look at. Congress debated it, it considered this language, it considered that language. With Title VII, we have zero, and I mean absolutely zero legislative history on how sex, what Congress meant when sex got added to the 1964 Civil Rights Act. In 1964, obviously, the Civil Rights Act was very controversial. It was intended to stop discrimination based on race, color. They also included national origin and religion. Sex was not in it. A lot of congressmen, and then it was congressmen, were opposed to having Title VII and the whole 1964 Civil Rights Act passed. Representative Howard Smith, a Democrat from Virginia, said, well, and there's different versions of the story, but the most reliable version is he wanted to scuttle the 1964 Civil Rights Act, and he said, I know how to do that. I'll throw sex in, and then I'll get a whole bunch of people to vote against it because they won't want to protect women, even if they want to protect people from racial discrimination. 11th hour, I mean, it was right before the act was voted on, he threw sex into the act, and it passed, including sex, but they hadn't discussed what does sex mean. So now we have all the litigation after 1964 to try to help us figure out what does prohibiting discrimination based on sex mean. Before the 1990s, there were a number of cases, and every single one of them brought by lesbians, gays, and transgender people. The employees who were discriminated against lost. The courts all said discrimination based on sex means discrimination based on the fact that you're a man or the fact that you're a woman. So the classic case when we used to have rules that only men could be airline pilots and only women could be flight attendants, all the courts said that's all that we're talking about is those kinds of things where certain jobs are limited to men and other jobs are limited to women. All of this started to change with two big cases, Price Waterhouse and OnCal. And you're going to hear both of these cases being argued today, so I want to just give you a little bit of background on both of those cases. In 1989, the Supreme Court decided Price Waterhouse versus Hopkins. In this case, Ann Hopkins, a woman, applied for partnership in Price, or was being considered for partnership in Price Waterhouse. They denied her partnership, and partners said some brilliant quotes like, she's too macho, she needs a course in charm school, she was advised to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. All these things are really critically important for a partnership. The Supreme Court said Ann Hopkins has stated a cause of action under Title VII because she was being judged based on stereotypes of how women should act and behave. And so this gave rise to what you'll hear the attorneys here arguing, the gender nonconformity or the sex stereotyping theory of recovery. One important quote from this case is the Supreme Court said By focusing on appearance and behavior, however, we do not suggest a limitation on the possible ways of proving that stereotyping played a motivating role in the employment decision. So you're going to hear arguments about that. The second case that made a difference in how the courts were deciding these issues was a 1998 case. It was a unanimous decision written by Justice Scalia on Cal. Cal was a male worker on an oil rig. He was very effeminate, and he was subject to horrendous harassment, awful harassment. The unanimous courts, and the issue before the court was, can male-on-male harassment be actionable? In other words, is Title VII only limited to opposite-sex harassment? And the court said, no, male-on-male harassment is actionable, and Cal can state a cause of action. And the important quote to pay attention to here, that again the attorneys will be arguing, is male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII. And then it continued, statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. So with this language, Scalia opened up the door to additional causes of action. After these two cases, Price Waterhouse and Cal, the courts started splitting, and that's why the Supreme Court has granted cert, because we have this huge split among the courts. So here's the three approaches that have happened in the lower courts. Some courts are saying, and this is also true in government agencies too, so I'm going to mention the courts and I'm also going to mention government agencies. Some courts are saying, if transgender and gays and lesbians are being discriminated against because they don't fit the stereotype of, and here I'll just use male, but obviously vice versa, if somebody who was identified as male at birth doesn't fit the stereotype of how males should dress and behave, that's sex stereotyping under Price Waterhouse. So some courts are going that route. Some courts are taking it one step further and saying, look, it's just straightforward sex discrimination. If this person had been identified as a female at birth, they wouldn't have suffered discrimination. It's sex discrimination. And then finally, some courts are saying, Price Waterhouse and Cal didn't change the original intent of Congress to prohibit only discrimination because you're a man or because you're a woman. So these courts are saying no recovery at all. We're seeing the same thing in executive agencies. So what's happened is under Obama, a number of executive agencies started interpreting sex discrimination to include prohibit discrimination against transgender people and lesbian and gay people. So that was true in the EEOC, which the EEOC is the agency responsible for enforcing employment discrimination actions. So the EEOC said sexual orientation and gender identity are prohibited. The Department of Justice said the same thing. The Department of Education said the same thing. Under Trump, the agencies are starting to reverse themselves. So the Department of Justice and the Department of Education now say, no, LGBT people are not protected under our regulations. However, and this is the interesting thing that I'm not going to drive you crazy with, the EEOC hasn't changed its position. The EEOC is still saying they're protected. So we have an interesting split. There are so many amicus briefs that have been filed in these cases. One interesting one is one filed by more than 200 corporations. Many of these corporations are the huge corporations that you would recognize, and they have filed saying sexual orientation and gender identity should be banned, discrimination should be banned under Title VII. So, what are we going to hear today? Here's the arguments that you're going to hear discussed today. Whether Title, and this is the Supreme Court language, so this is the Supreme Court saying this is what we want to hear. Whether Title VII prohibits discrimination against transgender people based on either one, their status of being transgender, the sex discrimination argument, or two, under sex stereotyping under Price Waterhouse versus Hopkins. So these are the arguments that you're going to be being heard today. I just want to point out, one of the arguments at the circuit court before it went to the Supreme Court, Harris Funeral Homes argued, even if we can't discriminate based upon the transgender status, we have an exemption because we are religious, and we say that it violates our Christian beliefs to allow a transgender person as an employee. That's a super hot topic. The Supreme Court said, we don't want you arguing that topic, so you're not going to hear any discussion on the religious exemptions. My guess is next year when we're back here, that's going to be the case that's going to be heard, because there's cases all over the country on that, and it's really controversial, but the Supreme Court has said we're not taking it on this year, but they're going to have to take it on soon. So these are the arguments you'll be hearing today.
Let's get this moot court started. Chief Justice, Your Honors, and may it please the court, my name is Fernando Arroyo and I represent the petitioner, RG and GR Harris Funeral Homes. I would like to request 1 minute for rebuttal. Congress enacted Title VII to prohibit employers from discriminating against any individual because of sex. The case before us presents this court with an opportunity to clarify sex discrimination jurisprudence. In my time before you today, I will be addressing whether Title VII prohibits discrimination against transgender status or sex stereotyping. Title VII does not, and we respectfully request that you reverse the ruling of the Sixth Circuit for the following 2 reasons. First, Stevens' transgender status claim does not fall under Title VII's prohibition on sex discrimination. Second, Stevens has no claim for sex stereotyping. Now to my first point. Harris Homes is a family-owned business that for over 100 years has had one main goal: to help grieving clients heal as they let go of a loved one. In order to accomplish this goal, Harris Homes and all its employees agreed to abide by a professional dress code, which for over a century has allowed it to succeed. Harris Homes did not discriminate against or dismiss Stevens because of sex. According to this court in Manhart, sex discrimination under Title VII is found when employers treat one sex more favorably than the other. In Manhart, sex discrimination under Title VII was found when their 2,000 employed females were required to pay more money into a trust fund account as opposed to the amount required by 10,000 men, showing that males were being treated more favorably than females. In the present case, Manhart is distinguishable to the present case in that Harris Homes' dress code was implemented equally to all its employees. Neither males nor females received any special treatment, nor did Harris Homes intend to treat any sex more favorably than the other, proving that Harris Homes does not treat any sex more favorably and that it did not discriminate because of sex under Title VII.
Okay, very quickly. So you want us to believe then that the dress code is separate from the argument of sex. The question that I have for you is, what was the violation specifically of the dress code? If in this particular case, Amy Stevens was choosing to abide by what is the female-specific dress code, is that a violation? Or is Amy Stevens identifying herself as a woman and thus following what she believes that dress code to be? The difficulty that I'm having here is that it doesn't seem like it's a violation of dress code. It seems to me that it's Amy Stevens' choice to present herself as a woman, which goes to the idea of gender nonconformity. The discrimination here is based on gender nonconformity, not necessarily based on a dress code. It's the fact that Amy Stevens is choosing to wear a dress, which is the issue. So we can't remove the dress code issue from the sex issue. Amy Stevens is choosing to wear a dress as a way of identifying herself as a woman. the issue here is this sexual, as we were saying, is it gender prejudice, is it gender stereotyping that we're looking at here? I can't see our ability to remove the two.
Well, Your Honor, I would have to disagree in that here, what Stevens is doing is that she's merely expressing obviously her discomfort for a dress code. What Stevens has to prove is whether she is being treated less favorably than anybody of a different sex.
Stevens was specifically declaring that she was going to begin presenting herself as a woman at the workplace. Is that correct? That isn't simply discomfort, correct?
Well, Your Honor, regardless of what Stevens' sex is or what she declares it to be, the point is that Harris Holmes would have dismissed any individual that would have not abided by the dress code, showing that Harris Holmes did not discriminate because of sex, or regardless of anybody's sex, the same outcome would have resulted. Stevens' transgender status claim does not fall under Title VII because it is not expressly stated in the statute. Stevens points to on Cal, where this court held that there was nothing in Title VII that excluded same-sex sexual harassment. However, Stevens misapplies on Cal in the present case for two main reasons. First, the present case does not involve sexual harassment, nor is it a same-sex sexual harassment case.
Excuse me, but don't you think this is actually a case of gender discrimination? You keep bringing up the fact that this is sex discrimination. Don't you believe you may have a better argument under gender discrimination? There are numerous lower court cases such as Glenn v. Brumby, Rosa v. Park West, that support the fact that individuals who are transgender and are discriminated based on that are supported under Title VII.
Well, Your Honor, to agree with you in that, I would say that we're not saying anything about like sexual harassment, and that's why we're saying that the Stevens' use of on-call is misapplied because, yeah, this case has nothing to do with sexual harassment, or we're not even, Harris Holmes is not discriminating because of sex either. And that's why Stevens misapplies on-call because this case does not involve sexual harassment. And the second point is that on-call did not change Title VII to new classifications. On-call merely clarified and reaffirmed that the critical issue within Title VII is to determine whether a member of one sex was being exposed to disadvantageous conditions that members of the other sex were not. And in the present case, Stevens was not being exposed to any disadvantageous conditions. Every employee at Harris Holmes was exposed to and had to abide by the same professional dress code, and regardless of the individual's sex, Stevens would have been dismissed, or anybody would have been dismissed if they failed to abide by that dress code, showing that Stevens did not endure any disadvantageous conditions of employment as opposed to other members of a different sex.
And so how do you then think about the Price Waterhouse precedent in which clearly if Hopkins had exhibited the same kind of behavior and she had been a man, that would have been perfectly fine. If Amy Stevens had continued to dress as a man, that would have been fine. How do you comport with that?
Well, Your Honor, I'm glad you brought that up because that leads to my second point in that, Stevens doesn't have a claim for sex stereotyping under Price Waterhouse. According to the court in Price Waterhouse v. Hopkins, sex stereotyping was used as evidence to prove that sex discrimination under Title VII existed. It didn't create its own claim for sex discrimination. In Price Waterhouse, sex stereotyping was used as evidence to prove sex discrimination under Title VII, which in Price Waterhouse, the sex stereotypes that were used were that Hopkins wasn't promoted to partner because she was too macho for a woman, she was too aggressive in the workplace for being a woman, and that she was not feminine enough to be a partner. All of these sex stereotypes about how a woman should be were used as evidence to show that Price Waterhouse had discriminated against Hopkins. However, the present case does not rise to the same level as Price Waterhouse in that Stevens fails to present, and Stevens argues that an implemented dress code on itself is considered sex stereotype, which misapplies the standard in Price Waterhouse.
So, counsel, doesn't the Harris Funeral Home have a specific dress code that's specific for women as well as for men?
Yes, it does. However, regardless of any individual sex, if a male wanted to dress as a female, or if a male wanted to dress as a female wanted to dress as a male, regardless of the individual sex, the same outcome would have arisen that Harris homes would have dismissed that individual.
Is Ms. Stevens a female who wants to dress as a female?
Even if we have a transgender individual, if Stevens is claiming he's a male, and if Stevens is a male who was given the assignment of male at birth, and he wants to dress as a female, he's still not abiding by the dress code. Thus, for the foregoing reasons, this court should reverse the ruling of the Sixth Circuit. Thank you.
Good morning, Mr. Chief Justice, Your Honors, and may it please the court. My name is Thea Haushan, Solicitor General of the United States of America. Title VII's prohibition of sex discrimination is a strong and vital principle that underlies the integrity of our workforce. Today, the question on which this court granted review is whether that prohibition extends to discrimination against transgender people, based on their status as such, or by sex stereotyping under Price Waterhouse. It does not. This is a conclusion of law, not policy, based on two reasons. First, the central public meaning of sex in the specific context of Title VII was understood to afford equal opportunity to women and men. And second, Price Waterhouse did not interpret Title VII to bar sex stereotyping per se. Members of Congress voting on Title VII in 1964, and any politically engaged citizen at the time, would have understood the inclusion of sex as securing the rights of women to equal protection in employment by eliminating workplace inequalities that have held women back from advancing in the economy, in the same way as the other protected classes. Title VII's text makes clear that the prohibition on sex-based disparate treatment bars only employment practices that treat women less favorably than similarly situated men because they are women, or vice versa. Treating a transgender person less favorably than a non-transgender person because he or she is transgender does not fall within that bar.
Counsel, could I ask you, the word sex itself, is that a clear definition? If the Title VII is clear, why doesn't it just clearly say man and woman? Why does it say sex?
You're correct, Your Honor. So in the particular context of Title VII, which is a legislation that was originally passed to eliminate employment discrimination against racial and other minorities, it becomes especially clear that the prohibition on discrimination because of sex referred to unequal treatment of women and men in the workplace. Just within the particular context, Your Honor, of Title VII and in 1964. There is also no evidence that in 1964 the word sex would encompass subjective inquiries into a person's gender identity or transgender status.
But we can accept that in the 1960s, the transgender community was far from being acceptable. Thus, despite the fact that the community existed, there wasn't going to be much conversation in support of that community at that time.
Your Honor, statutory interpretation, as you know, begins with the text. And where statutory language provides a clear answer to a particular question, the inquiry must also end there as well. But here, you are completely correct. We are without a statute-specific definition of sex. And so we must interpret it as taking its ordinary contemporaneous common meaning. Biological sex refers to the physiological distinction between male and female. Specifically, it refers to an individual's chromosomally driven physiology and reproductive function. But regardless of the definition of sex, for the purposes of the litigation today, we are only concerned with whether Title VII as written currently bars the discrimination at issue.
So don't we need to look not only at what happened in 1964, but if we're looking at congressional intent, don't we also look at something more current than 1964? And don't we have the EEOC that's responsible for enforcing Title VII, interpreting it to include transgender people, and Congress not correcting that?
You're correct, Your Honor. Subsequent action by Congress also confirms that it is never understood or intended Title VII to cover transgender individuals as a protected class. Congress has amended Title VII in various respects in the 55 years since, but the core text of that prohibition remains the same today. Congress has specifically prohibited gender identity discrimination in multiple other statutes, but it has not taken that step in Title VII. And so it is ultimately the provisions.
So you're asking the court then to redefine sex as inclusive of gender identity? How are you asking the court to define that sex specifically?
Your Honor, respectfully, the courts today do not have to come up with a universal definition of sex in order to resolve the issue in this case. We are only concerned with whether Title VII as written bars this discrimination at hand. The critical issue, as indicated by the text of Title VII, is whether members of one sex are treated less favorably or are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. Nothing in Price-Waterhouse casts doubt on that core requirement of a Title VII disparate treatment claim based on sex. It didn't recognize sex stereotyping as a novel freestanding theory on a Title VII liability. In Price-Waterhouse, Your Honors, you may know that the employer denied the plaintiff promotion based on her perceived aggressiveness. Now, this employer could have penalized that same trait in all of his employees for reasons unrelated to sex, and doing so would not give rise to a Title VII disparate treatment claim. But in that case, there was evidence that the employer penalized the plaintiff because she was a woman, and it was largely based on stereotypical notions about women's proper deportment. But Price-Waterhouse produced no majority opinion, and it merely addressed that evidence of sex stereotyping may, but will not always show that an employer relied on sex in taking a particular action, still under the ordinary Title VII rubric. And whatever probative value evidence of sex stereotyping might have in a particular case, it does not excuse the plaintiff from the fundamental requirement of proving that the defendant treated individuals of one sex less favorably than similarly situated members of the other. Here, Harris Holmes could not be liable on a sex stereotyping theory because it had not treated male or female employees less favorably than similarly situated members of the opposite sex.
Counselor, I still think we haven't had an answer to the question specifically about how Chevron governs this case, because clearly the EEOC has the ability to interpret the statute. And in the absence of Congress overturning this EEOC's interpretation, why shouldn't we allow that interpretation to stand?
So the Department of Justice, Your Honor, cannot extend the law beyond what Congress has provided. And in terms of the EEOC, it is ultimately the provisions of our laws that govern us, rather than the primary concerns of an executive agency like the EEOC or even our legislators. Congress has consistently declined to construe sex to encompass transgender status, even while amending Title VII in other respects. And until
Wouldn't that be because they were happy with what the EEOC did?
Policy questions, Your Honor, about whether that may be true might be a better question for Congress than for the courts here today. But unless and until Congress comes up with a new meaning for sex, the proper role of the executive and of this court today is to faithfully enforce the law as written. Title VII's protections apply fully to transgender individuals, but the fact that a plaintiff is transgender does not alter the legal standard. As it stands, Title VII prohibits treating individuals of one sex less favorably than similarly situated members of the other sex. But that does not mean that transgender individuals are somehow excluded from Title VII protections. It only means that transgender individuals must make the same showing as any other plaintiff. The Department of Justice must and will continue to affirm the dignity of all Americans, including transgender Americans. Thank you very much for your time, and we respectfully request this court to reverse.
Good afternoon, Chief Justice, Justices, and may it please the Court. My name is Dal Storing, and I'll be addressing the issues on behalf of the respondent, Ms. Amy Stevens. In 1964, Congress took steps to protect all Americans from workplace discrimination. Title VII prohibits employers from firing an employee based alone on their sex. That is exactly what Harris Holmes did in the present case. Ms. Stevens was an ideal candidate, but one thing is different about her. She's transgender. Harris Holmes fired Ms. Stevens because she did not conform to the views of Harris Holmes of how men and women should identify, look, and act. Therefore, we respectfully request that this court affirms the appellate court's decision for the following two reasons. First, Harris Holmes clearly violated Title VII when it fired Ms. Stevens because of her sex. And secondly, there's no basis for excluding transgendered individuals from Title VII protection. Now turning to my first point, Your Honors, employment opportunities cannot be limited based on an individual's sex. That this is, quote, artificial, arbitrary, and unnecessary. That's what this court decided in Griggs versus Duke Power Company. Furthermore, in Price Waterhouse versus Hopkins, this court decided that employers' decisions should focus on the qualifications of the individuals rather than their sex. Here, Harris Holmes testified in the previous court that Ms. Stevens was, quote, able to perform the jobs of a funeral director and an embalmer, that she showed sensitivity and compassion to the clients who came in to Harris Holmes, and that she was an incredible embalmer worthy of the position, end quote. Ms. Stevens worked for Harris Holmes for over 2 years, but yet was fired because she decided that she was transgendered. Now, in 1991, Congress amended Title VII to establish unlawful discrimination when an individual can show that sex was a motivating factor for any employment practice, even though other factors were motivating within that practice. Ms. Stevens was going to continue to wear the appropriate business attire as a woman, yet Mr. Rose, the owner, claims that there was no way that Mr. Stevens would be able to present himself in a way that would not be obvious that he was a man. Mr. Rose further claims that restrooms would play a factor because customers would feel uncomfortable. Mr. Rose made it clear in his deposition that he would have fired Ms. Stevens because she was no longer going to represent himself as a man. Harris Holmes would not have fired Ms. Stevens for living openly as a woman if she had been assigned female at birth. However, Ms. Stevens was assigned the male gender at birth and wanted to live out her life as a female going forward. In Phillips versus Martin, this court decided that, quote, characterizations of proper domestic roles of sexes are not to serve as predicates for restricting employment opportunities. And the court went further in Price Waterhouse, in which Ann Hopkins' employer suggested that she would receive a promotion only if she became less macho, began to walk and talk and dress more femininely, wore makeup, had her hair styled, and wore more jewelry. The facts are identical in this case, Your Honors. If Ms. Stevens would have dressed like how she was assigned at birth, a male, meaning dress, walk, talk, and acted more like a male, she would not have gotten fired. Which leads me to my second point, that transgender individuals are protected under Title VII. Harris Holmes makes the argument that Title...
Excuse me, Counselor, can you address Harris Holmes' argument that they're a funeral home, they're dealing with distraught people, and Ms. Stevens would not be able to fulfill that role effectively if she's dressed as a female and perceived as a male.
We respectfully disagree with that argument, Your Honor, because Ms. Stevens in this case was still able to fulfill her duties and her performances that are required as a funeral director. And she was willing to dress as a female in the appropriate attire. So she was going to go and meet the requirements that Harris Holmes was setting forth. However, one thing was different is that they disagreed with the notion that a transgendered individual can perform and fulfill their duties as a funeral director. So making the argument that the customers coming into the funeral home would be bothered or taken back by the notion that a transgendered individual was working at Harris Holmes is a flawed argument and is a clear violation of Title VII because they're making the decision on the basis of sex. And that's at the heart of this issue, is that Harris Holmes is taking Ms. Stevens' sex into consideration when they decided to fire her. She was assigned the male birth or male sex at birth. However, she's choosing to continue to live her lifestyle as a female.
Counsel, can't we at least assume that the owner of the Harris Funeral Home has a vested interest and that this might cause something a little bit more than de minimis cost against him or a burden against him? Doesn't he have the right to be concerned about that?
Yes, Your Honor, and employers have the right to take into consideration the other factors that contribute to it. However, at the end of the day, it is a broad meaning of Title VII that individuals cannot be fired by their employees on the basis of sex. So while financial obligations and financial losses can play a factor, they still have to abide by the federal protections that Title VII render. And it is a clear violation of Title VII to fire someone on the basis of their sex. Now, Harris Holmes makes the argument that Title VII does not prohibit discrimination against transgender individuals because it's impossible that sex in 1964 could have meant gender identification. This argument is flawed for a number of reasons. One being that if Ms. Stevens was assigned female at birth, she would have been able to freely live as a female. Here, again, she was assigned male at birth and she intended to live openly as a woman. At the basis of that goes against the Title VII protection under the sex classifications. Just firing an individual for wanting to change the religion, this court has decided that forcing an individual to change their religion is also a protection under Title VII. And that's what happened in Schroer versus Billington Company in the District Court of DC that held that firing an individual for wanting to change religion is religious discrimination. So too, firing a person for wanting to change sex is sex discrimination. That individual in that case was a Protestant employer. A Protestant employer fired employees who were born into the Protestant faith but wanted to convert to Catholicism. It is discrimination because the employee intended to convert to Catholicism. The same facts is true for people who state that they plan to change their sexes. That's exactly the case here before us today. Furthermore, allowing Harris Holmes to fire an individual on the basis of their own morals and beliefs is faulty. Some people might claim that women's place is inside the home. Your Honor, sitting on the bench, you would not be here before us if we would allow that discrimination practice to go forward, allowing employers to decide how men and women should act. And so forcing Ms. Stevens to comply with how she was assigned at birth, putting her into a specific box, goes against what Title VII protection renders.
One thing I want to ask you about, and this is kind of a bigger picture in this case, maybe, but is the court really the place to sort this out? I mean, isn't this better decided among the democratic citizenry through the lawmaking process rather than through the courts?
Your Honor, we respectfully disagree with that notion that it should be up to Congress because this is a statutory interpretation of what sex means in the present case. And we're asking this court to identify that gender identification and transgendered individuals are protected under the meaning of what sex under Title VII renders. And finally, Your Honors, I'd like to address the issue on on-call, in which the notion that Congress did not intend Title VII to include transgender individuals back in 1964, again, is flawed. And Justice Scalia, one of the most conservative black letter law justices on the bench, gave the opinion that stated statutory
Yes, but that may be true about 1964 and the Civil Rights Act, but we've had many decades between then and now, and still Congress has not amended any of the existing laws to include transgender individuals under Title VII. How do you address that?
Yes, Your Honor, which goes to the quote from Justice Scalia saying that statutory prohibitions often go beyond the principal evil to cover reasonable comparable evils. And so the meaning back in 1964 might not have meant including transgendered individuals, because that was not an issue back in 1964 as is now. The transgendered individual community is more prominent and well known amongst the community.
But again, then going to my colleague's point, allow Congress then to make those changes to the law as opposed to the court.
Your Honor, if I may, 30 seconds to answer your question as my time has expired.
Yes.
Including the transgendered individuals within the definition of the statutory definition of sex under Title VII back in 1964 didn't necessarily know and understand the capacity of what gender identification, because they weren't knowledgeable about the issue compared to now in 2019. And therefore, Your Honors, we respectfully request that you affirm the appellate court's decision. Thank you.
Chief Justice, Your Honors, and may it please the court. Professional dress codes exist for a reason. They exist to promote professionalism and order in the workforce. Stevens claims that Harris Holmes dismissed Stevens because of sex, but has failed to show that Harris Holmes favors other sexes, which is the standard. Harris Holmes is not asking this court to create an exclusion of transgender individuals. Instead, it asks this court to apply the law as expressly stated and refrain from usurping the role of Congress as provided by the United States Constitution. Thus, for the foregoing reasons, this court should reverse the ruling of the Sixth Circuit. Thank you.
So I'd like to ask some of the Moot Court students who are here to talk about their thoughts after hearing the argument and hopefully get you guys involved in the discussion as well.
You guys are referring to all the students here?
Correct.
So now you've heard both sides from the petitioners, basically the ones who are asking the Supreme Court to reverse. You heard from respondents, which are the ones that are asking the Supreme Court to affirm. So what do you guys think about the arguments that you guys heard today? Yes, he is in the back.
Stand up, maybe.
I think, honestly, if she was willing to be able to dress professionally as a woman, that it shouldn't really have mattered if the dress code was a problem.
Okay. Yeah, that is a very interesting perspective to look at it. Yes.
Was she ever given some kind of probationary period where she could attempt to dress within the accepted dress code, or was it just not at all?
Yeah, it was within the instant that she decided that she came out to Harris Holmes that she would wish to identify and dress as a female. That's exactly when Harris Holmes fired her. So she wasn't even given the opportunity. It was all hypothetical that customers would feel distraught or feel unwelcome or unbothered by her deciding to live as a female.
Well, according to Harris Holmes, they say that the owner of Harris Holmes did give, he thought about, like, if he did allow Stevens to dress as a female, and he expresses that he gave a lot of consideration according to like what clients might think, or if what would clients think of using like a male using a female.
Can you speak up a little bit?
That Harris Holmes, the owner of Harris Holmes did give some consideration to that, but obviously, yeah, in the end, he said that wasn't.
kind of to your point there, so was it just his consideration, or did he actually go out and survey people and provide evidence for this?
No, it was just
His own beliefs.
Can I just ask a show of hands, because I'm very curious how you've responded to the arguments. So could we just do a show of hands of how many people would decide in favor of the funeral home and how many people would decide in favor of Stevens? So how many people would decide in favor of the funeral home if you were a judge on the Supreme Court? And how many people would decide in favor of the employee? Interesting.
I think I thought you were raising.
Yeah, so there were no instances of clients reporting the defendant, or, sorry, I don't know law terms, not a law student, but there weren't any reports of disturbances. Nobody was bothered by it. It was just.
She wasn't even given the opportunity to live that lifestyle. She wasn't even.
So she couldn't proceed to carry on her duties.
She was, the instant that she was told Harris Holmes that she wanted to live as a female, they fired her there. So she wasn't given the opportunity to live and dress that way. So it's all speculation on Mr. Rose, is the owner, who fired her.
Okay.
I just have to say, I kind of feel particularly bad for you guys sitting there having to make that, yeah, because like the basis, like the word discrimination, you guys gave your definition as, you know, showing favor to a group, and if the employee was fired, like that, it was pretty clear that that was discrimination. So I would have a hard time, like, with my conscience having to say, like, actually, no, they weren't discriminated. And we give the definition for you, but still, like, no. Like, they weren't discriminated against.
Yeah, when we were, trying to, we read their briefs, and when we tried to come up with an argument, we had a tough time in trying to, like, come up with
We knew we were
good-
going to get pushback.
Yeah, well, that's the thing that lawyers have to be prepared to do. You're not always going to be supporting, like, a side that you believe in, but you still have to be able to defend your client. So that's our job.
Can you stand up again?
Did the funeral company or business ever stated that they had any religious beliefs, or was their business founded on religious beliefs, or did they just fire?
It was actually what I was able to read from this case. There was religion was influenced to the funeral home's decision to fire Ms. Stevens, but that issue is not going to be argued in the Supreme Court. That's just that's something that they.
But then wouldn't that be discriminating their beliefs from the funeral home if it was a religious purpose and they weren't?
Yeah, so that's not an issue that's going to be argued in the Supreme Court.
That was our argument, is that at the heart of it is that it was on the basis of sex and not religion, that Harris Holmes violated the protection of it because they fired Stevens on the basis of sex. And so we kind of molded it into that argument that religion didn't necessarily play a factor at law that we were arguing, even though it might have deep in their mind.
If it was fought against the religious perspective.
And I would like Professor Greenberg maybe to weigh in. I'm just asking because I think some students might be confused because of the cake shop case.
Yes.
And why did that get brought up and how does that play in? And maybe you can speak to why religion isn't being brought up or can't be, or what the court decided as to why that could or could not be brought up in this case as a reason as to why in the cake shop case, because it was a gay couple here, it was because it was a transgender individual. Maybe some students might be confused about that.
Yeah, so very quickly to answer both questions. The reason I don't think the Supreme Court said they're going to discuss it is they're not ready. It's a fairly new topic. There's lots of cases percolating, and usually the Supreme Court waits until they get a number of cases, get contradictions between the appellate courts, the circuit courts, and then they resolve it. They tend not to try to resolve issues until they give it a chance to percolate through the lower courts. In answer directly to your question about, well, why shouldn't the employer's religious beliefs, isn't that what you're asking, get the same protection as the employee's gender? there's a long line of cases and rules, regulations. If you're gonna be serving the public, if you're opening up your doors to the public, you have to do it on a non-discriminatory basis. So again, if you said, well, we don't want to serve interracial couples. I mean, imagine the funeral home or the photographer or the cake maker said, we don't believe in interracial marriage, so we refuse to serve interracial couples. I think that most people would say, that's horrific. And it's really the same argument when you're talking about sexual orientation and gender identity. If you're going to make a profit off the public, you have to do it in a non-discriminatory way.
Can I just add very quickly a little bit to that? The question also came up, what was the difference between that and the cake shop? And it's the relationship between the two, right? In the cake shop, it was the business owner and a customer. And the business owner didn't want to make a cake for a gay couple. So that was that issue. The other one is the Hobby Lobby case, right? The Hobby Lobby case is similar because that was a case where, again, they were arguing that the owners had these very closely held religious beliefs that the business also absorbed, right? And so if you are a very religious person and you own a business, your business is also religious, right? But the difference in the Hobby Lobby case is that that case was about whether or not the Hobby Lobby could or should give contraception. So that's a more direct, let's call it violation of their religious beliefs, right? This one is about hiring and firing. So the relationship now is between employer and employee, and that's governed by Title VII. The interesting thing is that Title VII does have a religious exemption, but it's also a very strict one. And for me, it's crazy because the religious exemption is, again, protecting the employee from the employer. But they're trying to use this case to protect the employer from the employee.
And to add one more point, religious institutions, you know, a Catholic institution gets more protection than a workplace that isn't related to a specific, it's not the funeral home is not a religious workplace, whereas the Catholic school would be. So those are treated differently.
So like, for example, I was just discussing real quick, like Chick-fil-A, for example.
Can you stand up again? We can't hear you.
So we were just discussing that, for example, at Chick-fil-A, they close on Sundays because they have religious beliefs and they have said that openly their main platforms. So how would that be considered discrimination towards, like you were saying, they're open up to the public and I guess you can say they're discriminating sex. How would you guys see that?
Well, if Chick-fil-A refused to serve a gay couple who came in, they would have a problem. But Chick-fil-A choosing to say all our employees are off on Sunday isn't discriminating against anybody. It's just implementing its religious practices, but it's not resulting in discrimination against people who have to eat chicken on Sunday.
Question in the back? Yes. Based on what I heard of the arguments on both sides, it seems like the actual part of the issue is the definition or the difference between sex and gender and how they're not the same. Like the defendant for the funeral home is saying that they didn't discriminate based on sex because they have the dress code that makes them equal, whereas the plaintiff is saying that they're discriminating on gender because as soon as the defendant says or the plaintiff says she wanted to change her gender, that's when she got fired. So it seems like the real argument is that sex and gender aren't equitable, they're not the same, and that's kind of what the hang-up is. Even though most of us think of sex and gender as being the same, the law doesn't define it as being the same. So is that, did I miss that or did I get that? Or?
That's exactly it.
You can sign up for Thomas Jefferson School of Law.
Come on over.
Can I just add though, as someone who's trying to teach about American government, one of the things that's so interesting about this case to me is that you have a conflict between an executive agency, the EEOC, and how they want to interpret a statute that was written in 1964. So this whole case started because the EEOC said, yeah, sex, that includes sexual orientation discrimination or gender identity discrimination. And just the very fact that the bureaucratic part of the government can do that is very interesting. And it helps to kind of illustrate how the pieces of the government work together. So So Congress didn't really weigh in, and never has weighed in specifically on that interpretation of Title VII sex, as including gender identity and sexual orientation discrimination. And a lot of people say, well, if they haven't, then that must mean that they don't agree with it. But like Professor Greenberg pointed out, maybe they kind of do agree with it, but they just don't want to be put on the spot of having to say that they agree with it, right? So the bureaucratic agency kind of fills in a space and provides rights where Congress doesn't.
I'm going to interrupt half a second here. I neglected to allow for one announcement by Professor Rodriguez. And then I know some people are going to leave at 12:30. We can carry on the conversation, but let's let Michelle make her comment.
Oh, in the back, you probably saw already, we have a women in law club on campus. Wanted to invite people to express interest in that. They are considering right now extending the name to the pre-law club, Mesa Pre-Law Club. So this is about women and men, it's not just women in law. And it's just a fun thing. We visited Thomas Jefferson School of Law last year and sat in on a class and met with administrators there. It was a really fun event, so you can sign up back there.
And if anyone needs to leave, this is a great time to leave, and then we'll carry on.
So, any other thoughts about
I got a question.
Yes.
Sorry. Rodriguez. I believe you brought up a question why, I think it's you, why did we decide here in the courts as opposed to Congress with the democratic process, or however you worded it.
Yeah.
And I want to know why, too.
Yeah, well, it's a very good question. It was more of a rhetorical point, like there's not really I don't have a good answer to that particular question. But that's one of the claims that's being made is that this is a point of contestation still in society. We might not see that quite so much here in California, in San Diego, but in some parts of the country it still is a point of contest. And so we see, if you look at, in the assignments that you did in class, for instance, you looked at the maps of this kind of different state laws regarding sexual orientation discrimination and gender identity discrimination. It's a patchwork, right? So that suggests that there really is, it's still not been really decided. And so quite often in that situation, people say, well, it should be the democratic decision-making process that makes those decisions. We know that in the past, that means that they're not made, that people don't end up being treated equally. What were you going to say?
The decision, at least from how I see things, is that the court is kind of always been this moral compass of the country rather than being swayed so easily like politicians are. The court is a stable fixture of our moral compass, and that would be my argument to take it to the courts rather than these people that are coming and going all the time. And really, these people have their finger on the pulse of society for popularity's sake, and we need to not worry about popularity's sake, but what is morally right.
Right, and I don't want to take away from everybody else. I feel like the Mesa professors are kind of hogging the conversation here. But to add a little bit, and I think again it's a great question, that there's a difference between the roles, right? There's a role that Congress plays and there's a role that the courts play when it comes to law. Congress writes and enacts laws, but it's the court's job to interpret those laws. So however we write a law, whatever words we use, those can be interpreted differently. We can all come up with different interpretations of a law. So it's the court's job to have the official interpretations, so to speak.
That was kind of like what my argument was, is that sex at the time in 1964, the transgender community wasn't broad and as prominent as it is now. And so allowing the court to make that decision, because there's so many different meanings, Harris Holmes is arguing, no, it doesn't. We're arguing it does. So it's up to the court as a final stop to make that decision what sex means, and that we are arguing that it shouldn't be Congress making that decision. It should be the court to interpret the law, interpret the statute, Title VII back in 1964, to include or exclude transgendered individuals.
Can I make 2 quick points on this? One, that moral compass, the court being the moral compass of the country, is something that typically applies when you're talking about the Constitution, because no one can change that. Congress can't do anything about that. It's totally on the court to decide what the Constitution means. When you have a statutory case like this, it's a little different because Congress does have the power to change it. And so some people argue the court shouldn't really step in and do things if Congress isn't. The other thing though, and this is a universal argument in the law, is once you've got a law, how do you interpret it? Do you just read the words and try to figure out what they mean? Like the petitioners were arguing, sex in 1964, we all pretty much know what that meant, and we should just follow that. Or should we think about, should the court think about what was Congress's purpose in 1964? It was to prohibit the kinds of discrimination that seemed to be prevalent in the world then. And the fact that while we have other kinds of discrimination that we perceive now, it still seems to be within the purpose of Congress. And so this distinction between, are the laws the plain language of what they say, or do the laws also include the purpose that was behind them? It's like a continuing argument, and you can find so many cases where one side's arguing one and one side's arguing the other. And we may never have an answer to that. It's just always going to be battling that out.